Ma'am, shall we start, please? Yes, ma'am, we can. Okay, thank you. Greetings of the day, everyone, and welcome to the ITM session on the theme sexual harassment in the workplace. Today we have Professor Elmarie Fourie. She is the head of Department Law, Faculty of Law, University of Johannesburg, South Africa, and she is the guest speaker for today's session. A very small, brief introduction about ma'am. Ma'am, as I rightly pointed out, that she is the head of the Department of Law, Faculty of Law at University of Johannesburg, South Africa. She also is holding the head position for a lot of research projects, and she has been the coordinator also for a lot of research projects. She is also a member of National Committee for Legal Skills and a member of South African Society of Labor Law, and also she is the ambassador for South African Society of Labor Law Student Conference, and she is also a member of the Global Advisory Council for Therapeutic Jurisprudence. On behalf of Institute of Law, Nirma University, I welcome you, ma'am. And I will be the moderator for today's session. And this is the protocol I will be expecting all the students who have gathered here to follow. You are all requested to please switch on your video and turn off your microphones. Any question and answer will be addressed at the end of the session. So the session will be 50 minutes and the last 10 minutes will be taken for question answer session. And any questions which the students want to ask, they may please direct their questions to me using the message box that we have in this particular platform. And now, without any further delay, I would now request Professor Elmarie Fourie to please address the gathering on the theme sexual harassment in the workplace. Over to you, ma'am.
Thank you so much, and thank you for this wonderful honor and privilege to be here today. I'm really honored to be invited to participate in this wonderful initiative. I always say that the colleagues at the Institute of Law at NIRMA, we started out as colleagues last year, but I reckon you are now friends. We are more than colleagues, and I appreciate all the work. I always feel so welcome to participate in collaborations with you. So it's a real honor. I'm going to share my screen. Sorry, let me just... Okay, so my topic today deals with sexual harassment in the workplace. And this is a very important topic for us in South Africa. And I thought I'll share some thoughts on our sources. Sorry, let me just see if I can then move on to the next slide. Okay, I thought I'll share some of the sources with you and also the case law to give you an idea of how our courts in South Africa have dealt with sexual harassment in the workplace. So I will look at the sources that regulates this. I will discuss concepts. I will look at case law and then look at the various remedies available to a victim in South Africa. So if we look at our conceptual framework, we will see that with sources, we started the Constitution. Now, as you know, the Constitution in South Africa is the supreme law, and any law that's inconsistent with the Constitution can be declared invalid. Very important when we look at sexual harassment is that Section 9 of the Constitution is our equality clause, and it prohibits unfair discrimination on a number of listed grounds. It also promotes equality, and the Employment Equity Act was the act that was enacted to give effect to that clause. I also want to point out right at the beginning is that Section 10 of our Constitution contains the right to human dignity. Human dignity in South Africa is both a right and a value of our Constitution. And why I'm mentioning this is when I go through the case law, you will see that every time human dignity of the victim comes up very importantly. We then have the Labor Relations Act that regulates the workplace. And with reference to sexual harassment, and I'll talk about this when we get to the case law, here it sometimes happens that the workplace becomes intolerable for the victim. She cannot work there anymore because of the harassment. And then we have an option where she can resign because it's intolerable, However, that is seen as a constructive dismissal. So although the employee resigns, we regard that as a form of dismissal. And then I'm going to spend some time on the Employment Equity Act, because that is the main source that regulates harassment in the workplace. We also have what we call PEPUDA, the Promotion of Equality and Prevention of Unfair Discrimination Act. Now, this act covers everyone outside the workplace. So if you are not an employee, you will find protection under PEPUDA. And then we have the Protection from Harassment Act that deals with protection all over if there's sexual harassment. And lastly, our common law framework, which is the Roman Dutch law, influenced by the English law, is still relevant. And you will see when I go through the cases that certain victims choose to use the common law outside the legislative framework. For us in South Africa, international law is very important, and I'm proud to say South Africa has ratified the most amazing ILO instrument. I think this Violence and Harassment Convention is the best instrument ever drafted by the ILO, and I'll tell you why. We've ratified it. However, currently, I do not think South Africa complies with the principles contained in the convention, and it probably will mean that we will have to consider more legislative amendments than what is currently on the table. Why am I talking about international law? Because in South Africa, our constitution says that courts, tribunals, or fora, when they interpret the constitution, must consider international law. It's obligatory. We don't have the choice. The courts must look at international law, whether binding or not binding. In every court case, the courts must look at international law. So it's binding. We may consider foreign law, the laws of other countries, but international law is binding. I just quickly want to mention something around this convention. First of all, what is amazing about the convention is how it came about. It actually came about outside the tripartite nature of the ILO, because women organizations came together and they lobbied outside trade unions and said we need protection for women workers. And that is one of the first significant things. Something else that's extremely important around this convention, I'm sorry, I just want to go back one, is the conceptual framework of this convention. I think this is of the utmost importance. And I think all of us, South Africa and India, can learn a lot from the way this was drafted. If you look at Article 2, who's covered, look how wide this is. All people in the place of work, irrespective of their contractual status. Now, South Africa, if you're an independent contractor, you're excluded from all protection. Here we see it's wide. Volunteers, wide. We exclude volunteers from labor law protection. Job seekers and job applicants, we do include them in certain laws, but not in everything. And one of the most important things for both South Africa and India is the convention applies to workers in the informal economy. Now, India has a very large informal economy. In South Africa, we have a small informal economy. However, these workers are excluded from labor law protection. So they have to find protection under PEPUDA. So look at this wonderful, wide conceptual framework. I think this is a direction for all of us with reference to legislative drafting when we want to extend protection. Violence and harassment is also wide. During work-related trips, travel, training, social activities, in employer-provided accommodation. Why did I highlight that? Domestic workers. In South Africa, domestic workers are often provided with accommodation at the place of the employer. Now, this is a workplace. When commuting to and from work, isn't this amazing how wide the scope of this convention is? And then very important here is it refers to a single occurrence. And this is important when I do case law. It doesn't have to be more than once. A single occurrence can be severe enough to impair the complainant's human dignity. And I think that is very, very important. So my comments on the ILO convention, I want to congratulate the ILO convention. This is the first convention that I find that is so wide in the conceptual framework that it will extend protection. Problematic? enforcement in countries, incorporation in national laws. That is going to be a problem for many of us who have ratified this convention. Now, the Employment Equity Act covers applicants and employees, not the Labour Relations Act, but the Employment Equity Act does so. This statute gives effect to the Constitution and to the ILO Discrimination Convention. The purpose of the Act is to promote equal opportunities and fair treatment. How do we do that? We eliminate discrimination. And besides today's topic, it also talks about implementing affirmative action measures to redress previous disadvantages, a clear indication of a substantive law approach embraced by our Constitution. If I go and look at the Act itself, we'll see that the main section relevant to harassment in the workplace is Section 6. Now, Section 6.1 says no person may unfairly discriminate directly or indirectly. So the first thing we see here is that both direct and indirect discrimination is covered with reference to protection. We then find a number of grounds listed. There are 3 more grounds in the Employment Equity Act than in the Constitution. Family responsibility is mentioned, HIV status, and political opinion. If you look at the last line, it also talks about arbitrary grounds. Immediately when I see that, it means that that is not a closed list. It means it's possible that you may be discriminated against on a list that is not contained in Section 6.1. Then, and this was part of our Employment Equity Act amendments, Section 6.3 now specifically provides harassment of an employee is a form of unfair discrimination, and it is prohibited on any of the grounds listed in Section 6.1. So we now specifically provide and acknowledge that harassment is a form of discrimination. Now, interestingly enough, harassment is not defined in the Act. But when we look at the case law that I will discuss, we see that often when we determine whether there was harassment, the courts linked it directly to the impairment or the violation of dignity. Because harassment is not defined in the main body of the Act, we need to look elsewhere to see what is the meaning of harassment. Now, if we look at Papuda, it talks about conduct that is serious, demeans, humiliates, or creates a hostile environment. Now, this conduct that is serious has in the workplace now been clarified as also to mean a single incident. We also have a code. So a code provides nearby guidelines in South Africa, doesn't have the same binding nature as legislation. We have a code of good practice on the handling of sexual harassment in the workplace. And here we see the code talks about physical contact, touching, sexual assault, and then it moves from physical contact, sexual assault to rape or strip searches, verbal conduct, unwelcome, suggestions, hints, sexual jokes, victimization, sexual favoritism, and the code clearly indicates it can be a single incident or a series of incidents. So when we look at our code, we see that there is quite a wide scope of definitions in here. And then item 4 talks about the unwelcome conduct and the following factors. Was or did the harassment occur on a prohibited ground in Section 6.1, those listed grounds? Was it unwelcome? What was the nature and the extent of the sexual conduct? And very importantly, what was the impact of that? We have a complainant. I don't want to use the word complainant. I'd rather use the word victim. And we have the perpetrator. So we both have subjective and objective elements to this. And it's very important that employers in South Africa must develop policies with reference to the handling of sexual harassment. And those policies must include assistance and counseling. And sexual harassment is a form of misconduct. It's a disciplinary offense, and it's a serious offense that in most instances will warrant, in fact, in all instances, should warrant a dismissal. What are remedies? We've already talked about constructive dismissal. So if I am the victim of harassment under the Labour Relations Act, when my situation becomes intolerable, I can resign. and I can claim unfair dismissal. My compensation is then limited to 12 months. Keep that in mind, it's capped. Under Section 187, I can be dismissed based on my sex, gender, and that can also form a part of dismissal, and my compensation is 24 months. It is possible for a victim in South Africa to have more than one remedy, and I'm going to show you how that works. So I can either claim under the LRA constructive dismissal, I've got 12 months compensation. At the same time, I can bring a claim under the Employment Equity Act and say, I was discriminated against in terms of Section 6.3, and I can claim compensation and damages in terms of the Employment Equity Act. But the burden of proof is different, and I'll show you the Employment Equity Act now. In the Labour Relations Act, if I claim constructive dismissal, I must prove the dismissal, and I must prove that the situation became intolerable in that workplace. I'm very proud of Section 10 of the Employment Equity Act because this amendment allows victims of harassment to now approach the CCMA. Now, the CCMA is free and it's speedy. Instead of having our victim go to the labor court, which takes a long time and it's expensive, if you are a vulnerable worker, if you earn below a certain amount, it's approximately 250,000 a year, you can now go to the CCMA. And I've spoken to the director of the CCMA, and since this has been in place, I'm very proud to say they have seen more and more cases being brought to the CCMA by vulnerable women in this sort of situation. You are always welcome to also agree to go to the CCMA. Both parties can agree. Now, in South Africa, if you take a matter to the CCMA, there's no right to appeal. You can only apply for review. I do agree the lines have been blurred, but because we recognize that harassment and sexual harassment is such an important issue in our workplace, we now make an exception. We allow for a right to appeal as opposed to normal review procedures. And I think that is an indication of how seriously our courts consider harassment in the workplace. And I really think this is a wonderful amendment to our Employment Equity Act, and it promotes access to justice, which is very important for these workers. Very briefly, if we look at Section 11 of the Employment Equity Act, you will see that there are two parts to the burden of proof. If you allege unfair discrimination on a listed ground, you will see that the burden of proof is placed on the employer. The employer against whom the allegation is made must prove that it didn't take place, it is rational. If it's unfair and it's on an arbitrary ground, it now goes to the complainant. So if it's not on a listed ground, the burden of proof is quite heavy on the complainant. Then in South Africa, our common law is relevant because we have a doctrine called vicarious liability. And this doctrine says that if an employee during the duty and scope of his employment does damages to someone else, the employer can be held liable. That's based on a DLIC. And that is part of our common law. But we also have this contained in legislation. So Section 60 of the Employment Equity Act says the employer can be held liable for the conduct of the employee if certain situations happen. However, it's not a strict liability like the common law, because if the employer can prove the following, he will not be held liable. So the conduct must be brought to his attention. The employer must then consult with the parties. He must take steps to eliminate the conduct. If the employer does not do this, and it is proved that the employee has contravened a rule, the employer can be held liable. However, if he did anything or everything reasonable possible, he will not be held liable. So it's clear that he can escape liability if he follows the procedure in Section 60, unlike the common law position. We also have the Protection of Harassment Act, and this is an act that's available to all, not just employees, but it gives effect to our fundamental human rights, and it applies to everyone. And here, the victim can actually apply to the magistrate's court for a protection order. And this is quite valuable. And there's been certain amendments, and I think this is an avenue for a complainant to use when she cannot come right for reference to the workplace. The first case that I want to look at, that I want us to consider, is the Simmers versus Campbell case. And there are two reasons why I want to look at this case. The first deals with the fact that this was a single incident. And then I want to show you how the Labour Court and a male judge, his judgment differed from the Labour Appeal Court, where we had a female judge. And I find this quite interesting. This case in South Africa is known as the "Do you want a lover tonight" case. And the question arose, these words, do they constitute sexual harassment? This one act of asking a contractor, do you want a lover, is that harassment in South African law? So what happened here was Simmers, together with another colleague and a contractor, a lady, Miss Marquides, went over to Botswana to do some work. And one night they had dinner, and after dinner the colleague walked away, and Mr. Simmers thought, this is my chance. And he said to Miss Marquides, would you like a lover for the night? And she said, no, thank you, I have a boyfriend. And she went into a room and he said, but listen, if you change your mind, please contact me. And she closed the door. She actually then keyed in the number of the colleague, and she was quite afraid. It then went to the Labour Court, and the question was, this behavior by Mr. Simmers, this comment, is this sexual harassment? Now, look at the Labour Court. We have a male judge here, and I think it's quite shocking what the male judge said. He said, yes, advances were unwelcome. She didn't ask him for this. And yes, it was inappropriate. But we must give Mr. Simmers this. He did not persist. And then he makes this comment. He says, men sometimes do this more in hope than in expectation. Isn't that shocking? A single incident cannot be sexual harassment. It must be serious. There must be touching or groping, he said. And he said there was no real workplace difference because he was not a senior. And according to the male judge in the Labour Court, this is normal male behavior. And he did not cross the line. Then it went to the Labour Appeal Court. And here we have a female judge. And she came out quite strongly with reference to the judgment in the Labour Court. She said, the Labour Court made a mistake in electing to make the unwelcome sexual advances to just say this was just, he was trying his luck. Mr. Simmers did violate Ms. Marquides' right to substantive equality. And I would just want to stop here because you're going to see in the following judgments every time substantive equality comes up. In South Africa, our constitution embraces both formal and substantive equality. Substantive equality is saying that sometimes we have to recognize that there's a particularly vulnerable group and we need to treat them differently. And in this instance, the complainants or the victims of harassment. She said it caused her to be singled out. He was opportunistic. She had to face his unwelcome advances in circumstances in which she was entitled to expect and rely on the fact that if you are in a workplace, you should not be subject to unwelcome advances. In treating the conduct as sexual harassment, saying that this single incident was sexual harassment, we are now saying we are protecting women. They are ensured of a safe workplace. They can engage constructively on an equal basis without unwarranted interference on their dignity and integrity. Point number 2, you will see in the judgments, nearly all the judgments in South Africa that deals with sexual harassment talk about dignity and integrity. And all these judgments are supported by the following sentences. This is what our constitution says. This is the protection under our constitution. And I think it's an amazing judgment if you oppose that to the Labour Court judgment. She felt unwelcome. She felt threatened by the behavior of Mr. Simmers. And this we must take in consideration. In fact, she was actually quite scared. The second judgment I want to look at is the McGregor judgment. You will see the next two judgment deals with different aspects, and it also deals with public organs. And this is a big problem in South Africa, sexual harassments where public organs are involved. Now, this looks at it completely in a different way, and I want to highlight this. Here we have a doctor, Mr. McGregor, and Mr. McGregor sexually harassed his intern. Clearly, we see the power difference here between them. He was the superior and she was his intern. He was then dismissed for sexual harassment. However, there were minor procedural irregularities. Despite that, he received nearly R1 million in compensation for the irregularities. That is after harassing this particular intern. So sexual harassment in this case occurred on several occasions. And the court said there's something wrong if we award a perpetrator of sexual harassment with R1 million. And it went right up to the Constitutional Court. And the Constitutional Court said, we can't do this. He can only get 2 months compensation. If we look at the severity of sexual harassment, as opposed to the labor law and unfair dismissals, they brought the R1 million down to 2 months. But I want to highlight something important here. So they look at compensation for an unfair dismissal, but they also looked at the reason. So if you are dismissed for sexual harassment, that impacts on the remedies if you are unfairly dismissed. But look at this again, the words that come up in our law: human dignity, integrity, the achievement of equality in a non-racial and non-sexist society under the rule of law. I want to highlight again, look what the court says. It strips away at the core of a person's dignity. It does not promote substantive equality. And you will see that our courts give us a little bit of advice as a society. It says we must do something and we must react strongly because sexual harassment promotes a culture of gender-based violence. And we do not want this. Our Constitution does not promote this. So the court went on and say, furthermore, at its core, sexual harassment has to do with the exercise of power and power relations. And then once again, we find this both in society and in the workplace. So you see the strong link in our court saying, yes, it happens in the workplace, but we have to talk about society about this because this is a societal problem. We can't see the one loose from the other. We have to address the issues in our society and address the issues in the workplace. And they then say something very important, and we've spoken about the intersection of discrimination before as well. They say sexual harassment occurs at the intersection of gender and power. And what is the result of this? And look how strongly the courts come out. The stench of subordination. Strong words for our courts. Disempowerment. Inequality, once again, bringing that to the society. All of these things seep through our society and it stains it at its core. Eradicating sexual harassment is not an easy task. But if we compensate them lavishly for their misconduct, we are promoting instead of eradicating sexual harassment in the workplace. So our courts are giving us a lesson, apart from using substantive equality, human dignity, violating. We see that they every time bring it back to society. And I think this is very important for us, where we battle with high inequalities, poverties, specifically vulnerable women. I think these sort of comments by the courts are of the utmost importance. And the court said in the Campbell case, the Labour Appeal Court said, why must there be a severe sanction on the perpetrator that does commit sexual harassment? Because it sends out a message that employees who does this do so at their own peril, and they will face a harsh penalty. Once again, you see the words, this is the protection which our Constitution affords. So overarching, we have the umbrella of our Constitution and the rights and the values of human dignity. And I think that is of the utmost importance. The last case is a very, very interesting case and also a very sad case, ladies and gentlemen. Why do I discuss this case? Because this action was brought by the victim in the High Court, outside the labor courts, outside labor legislation, outside the LRA, the Labor Relations Act, and outside the Employment Equity Act. This victim decided to use her common law remedies and bring the claim to the High Court under what we call the vicarious liability doctrine based on the elements of a delict. This took 10 years. She was 23 years old when this happened. It took 10 years until the final judgment in the High Court. This was a very high award. She wanted 8 million, but she got nearly 4 million in damages. And of course, it was clever because if you go to the labor court, your compensation will be kept. So, and even in the Employment Equity Act, we have not seen such a large award. However, you can see this is expensive and it takes quite a long time. So this was very much based on the common law. Once again, you see the party here is a local municipality, a state organ, ladies and gentlemen. And this is really a very sad case where we have the complainant that worked for the employer and the specific person who harassed her. And he harassed her in coming to a desk one day, and he forced himself on her, ladies and gentlemen. And she complained, however, very little was done about this. And in the end, her circumstances became absolutely intolerable. And she did have a remedy under the Labor Relations Act. She could have resigned and it would be a constructive dismissal, and she would get up to 12 months compensation. However, she did decide not to do this. We clearly see in this instance, there was a power differentiation. She was his employee and he was the boss. And once he harassed her, her health deteriorated and she suffered from post-traumatic stress. Her whole life was changed. The court said when or before this happened, she was a young, joyful 23 years old. After this has happened, she's really suffering from stress and post-traumatic stress. What happened, and this is shocking, when this occurred, what did the municipality do? They place her on special leave, and the perpetrator goes on as if nothing happened, no suspension for him. And she has to phone him and say, I've been placed on special leave. And he says to you, you're lying. You are lying, carrying on with the harassment. So he just ignored any instructions. They told him not to go to her offices. He continued to visit her offices and to intimidate her. The hearing was only held a year and a half, or half a year after the assault. Do you know what his sanction was? He was suspended for 2 weeks. That's all he got for severe harassment. Only suspended for 2 weeks by the disciplinary chairperson. Now, here's the first problem. Our Constitution says public organs have a duty to respect, protect, and promote and fulfill the rights in the Bill of Rights. If there's irregularities, they must seek to redress it. They should have taken this disciplinary chairperson on review. They did not do so. There was no counseling offered to her. She was marginalized and humiliated in the workplace. People were gossiping behind her back. She then brought this action in the High Court, and she claimed for damages, future psychological medical expenses, loss of income, future loss of income, because she was in such a state medically that she could not enter a workplace. She said if she just went back to that workplace, she would collapse. Even if she saw him in the street, she had a nervous breakdown. and she asked for general damages. I just want to read some of the comments or show you how the courts address this. The court said she will remain vulnerable, and that is because of her emotional position. Because she is vulnerable, she cannot compete for jobs in the open market. Even if she gets employment, also if she's treated differently and more sympathetically by her employer, it could cause disharmony and negatively affect her position. And he said, I take note of the circumstances that after the assault, she did not immediately resign, but she tried to work in these horrific circumstances. And he said, a judgment, and this is once again, look what our courts do. They comment, they're telling us what is wrong with our society. And he says a judgment of this nature would not be complete without something being said about the harm suffered by victims of assault. Listen to this. A sexual assault on a woman is a horrendous act. It's a severe violation of a woman's dignity. Here you see dignity again. A violation of her privacy, a violation of bodily integrity. It damages her reputation. It denies her intrinsic worth, her equality. You see the words equality again. And it dehumanizes her. It makes her into an object. So throughout these judgments, you saw the court's comments, the impairment of human dignity, the promotion of substantive equality, saying to the society, this is terrible. This is a horrendous act on women. We must address these issues. Our courts have reacted really strongly. And I've shown you 3 cases, one where we used the LRA, and we've also seen instances where we use the Labor Relations Act and the Employment Equity Act for 2 different claims at the same time. We saw the compensation case that went right to the Constitutional Court. And here we saw the common law being used to provide some relief to this victim of this. So conclusion, I am very interested to see what will be the impact of the ILO Convention on South Africa, because you must remember in South Africa, informal economy workers, except domestic workers, are not covered by labor laws. So what is going to happen? Will they still use PAPUDA? Will PAPUDA be expanded to cover them? Is there any thought about expanding the concept of employee in the Employment Equity Act to cover informal economy workers, because they are clearly included in the ILO Convention? There's been some amendments on the table, but nothing addressed this issue. I really hope that the legislative drafters in South Africa take note of the wide conceptual framework. I can report that 3 very progressive amendment acts have been committed by the president in 2019. They've been signed. They do not deal specifically with the workplace, but that is the Sexual Offences, Domestic Violence, and the Criminal and Related Matters Amendment Act. And this will also go a long way to promote substantive equality in the workplace. You can just go and read through some of these things. We see extensive definitions of sexual intimidation. Convicted offenders will be included in a national registrar, tightening protection orders, bail, removing dangerous possessions, and empowering the police to arrest when necessary without a warrant. So we see South Africa is coming to the party in this instance. I do feel that informal economy workers are often subject to harassment and sexual harassment by organs of state, such as street traders and waste pickers, and currently their remedies are very, very limited. Thank you very much, ladies and gentlemen.
Thank you so much, ma'am. We have few questions for you, which we would like you to answer. So the first question is, when the way you have talked about the mechanism to deal with the sexual harassment situations or incidents in South Africa. Now, the mechanism which has been provided there, is it only provided for the women employees or the female employees, or this sexual harassment protection can be provided to male employees as well in South Africa? Because in India, we have a specific legislation, that is the Prevention of Sexual Harassment at Workplace Act 2013, but it is only the protection is provided, or the mechanism is provided only to the women employees in India.
Thank you for that question. Everybody is covered, both male and female. We don't distinguish. The only thing is we've seen more cases brought by females than males, but it's quite possible there's no limitation to say only female. I think often females are in a more vulnerable position, specifically if we look at domestic workers, they are mostly women, but in South Africa, both male and female workers are covered by this.
Thank you, ma'am. We have another question. In case a situation of sexual harassment happens, but there are no witnesses which can be, brought before the court of law to prove that yes, it was indeed an act of sexual harassment, then how are such situations tackled?
Thank you. Yeah, that's difficult because it will depend on my word and your word. So at the disciplinary hearing, and even if you go to court later on, this will be on a balance of probabilities. The court will decide who is the best witness. That is definitely so. However, in some of the cases that I've mentioned now, for example, Simmers and P, there were no witnesses. But the results of the action was so severe that proved it. So it's definitely a thing of who's the best witness. That is definitely the question. It's difficult, and it will have to be proved on our burden of proof, which is on a balance of probability.
We have another question for you, ma'am. Thank you. The question is that when you talk about the act in India which deals with sexual harassment at workplace, it actually takes care of the privacy of both the complainant, who has made the complaint of the act of sexual harassment, as well as the alleged harasser. So the privacy is taken care of both the person who has harassed the complainant and the alleged harasser. Do you have in South Africa such kind of such kind of protection as well, where the privacy of both the parties is taken care of? Or if there's a person who has harassed somebody publicly, it will be made known to everybody?
Yeah, we have a general right of privacy in our constitution, but not a specific right in labor legislation. So the perpetrator, and if you look at the new amendments, there might even be a register where his name will be placed. So we don't protect the perpetrator. But in the one case that I discussed, the last case, you will see the parties are PE. They don't give the name of the complainant. So we protect the name of the complainant by only saying K or PE. We will protect that person. But if I look at the new enactments and there's a national register, a register where your name will be, the complainant does not have the same protection. And even in the cases, if you look at the last case that I discussed, the complainant's name is mentioned. However, not the complainant's name is not mentioned, but the perpetrator's name is mentioned. So we don't necessarily protect both parties. We will definitely protect the complainant, but not the perpetrator. But that also depends on the right of privacy. Remember, all our human rights can be limited. And in this case, I think if you make yourself guilty of such an offense, you might find that your right to privacy is severely limited in this instance.
Ma'am, we have one last question for you. The question is, the perpetrator for the acts or incidents of sexual harassment, it can be anybody. It can be a woman as well.
Absolutely. I use 3 examples of women, but it can certainly be a woman as well. We specifically have seen that in the sense of more bullying or discrimination, but yes, it can be a man, or a woman can also be the perpetrator. Absolutely. Unfortunately, the sad thing in South Africa is in our society, as you've seen in the news, women are particularly vulnerable. You've seen the domestic violence, you've seen the killing of women. So the instances where women are the victims are more, but certainly there's no exclusion. A man can certainly be harassed and discriminated against in the workplace by, for example, a woman. We just really have a sad situation in South Africa where women are particularly vulnerable.
Thank you, ma'am. Ma'am, just one more last question. in our Indian Act for Sexual Harassment, the act of sexual harassment has been specifically defined. So such kind of definition does also exist in the legislations what we have in South Africa, or it is based on the convention, that is Violence and Harassment Convention 2019, based on which any incident or act is identified as sexual harassment. Ma'am, you have to unmute yourself.
Okay.
Thank you.
Sorry. We have a code, the Code on Sexual Harassment, that is part of the Employment Equity Act. And the code provides guidelines very wide, very similar to the convention on what is harassment. But harassment and sexual harassment is not defined in the act. So we have to go to the code to find guidelines. And there we see a single incident. It can be verbal. It doesn't have to be a physical. We see very, very wide definition, very similar to the convention. And we now see that a single incident can also be classified, but we don't have a definition in the Employment Equity Act. It will be interesting to see if the convention now state allows us to perhaps expand the definition in the main act and not just in mere guidelines.
Thank you so much. So this marks the end of our session today. Thank you so much, ma'am, for the enriching session. I believe that the students have a lot of takeaways from this specific session. I will also request every participant to please look at the chat box, and I'm requesting them to fill the feedback form which has been circulated to them through the chat box. And thank you so much, everyone, again for joining this specific session. And I hope all of us have an amazing evening ahead. Thank you.
Thank you very much. And hi, Varsha. How are you? It's so nice to see you. It's nice to see you again. Thank you so much for this privilege and honor. I always like to collaborate with you, and I hope there's a lot of future collaborations. Thank you for having me. Much appreciated. Keep well and stay safe, everyone. We speak soon.
Thank you.
Thank you, ma'am. Thank you all.
Thank you, guys. I think Varsha is speaking, but she's muted.
Varsha, ma'am, I hope you.
Varsha, ma'am, will not be able to unmute. You'll have to make a co-host.
I will do that. I'll do that. I'll request the participants to please fill the feedback form.
Ma'am, just try. Yeah.
Thank you. Thank you so much. Hi, Elmarie. It was a very
Hi,
interesting
Varsha.
presentation. I could
Thank
join
you.
very late, but it was very, very enlightening.
Oh, I'm very glad, Varsha. I hope we meet and speak soon on future collaborations.
Yes, sure.
It's so nice to see you, and I hope I see you in person this year.
Hopefully.
You will come and visit us, and that will be amazing.
I think, yeah, we can really make it. I just received an invitation from Dubai. It's an Expo 2020, they call it. And it's an international event where they are looking forward to agriculture and livelihood of women.
Oh, wonderful. That's
So
amazing.
yeah.